By now, you should have listened to the recording by Professor Williams concerning the issue of piercing the corporate veil. Most people form corporations for the primary reason of protecting themselves from personal liability. And that's a great benefit that the states offer by allowing us to do that. However, sometimes owners of corporations abuse the corporate form by forming a corporation and then failing to treat it as a separate business, to respect the independence of the corporation. And they begin commingling their personal assets with the corporate assets, pulling out money whenever they need it, not keeping separate bank accounts, not having the meetings, keeping records that they're supposed to do. And sometimes when people start treating themselves and the corporation kind of as one entity, the courts will take away the privilege of protection from personal liability and do something called piercing the corporate veil. As Professor Williams talked about, there are two elements that the courts look to decide whether or not the corporate veil should be pierced. She went through them in her lecture, so what I'm going to do here is take the two cases that I assigned for you to do for your homework for today and go through those cases with you to show how the courts go about deciding whether or not the corporate veil should be pierced. The first case that I assigned was problem 9. Problem 9 took place in New York State. And New York had a law that required every taxi cab company to have $10,000 of accident insurance for every cab that it owned. We have an individual named Carlton who had 20 cabs, but instead of just forming one corporation to own all 20 of those taxi cabs, he organized 10 separate corporations. Each of those corporations owned 2 of the cabs, and Carlton was the majority shareholder of each of the corporations. And each corporation did what it was supposed to do by law. Each corporation carried a total of $20,000 of accident liability insurance, $10,000 for each of the 2 cabs that corporation owned. When it came time to operating the corporations, however, Carlton didn't really treat them as 10 separate companies. He operated them more or less as if they were just one big corporation. So all 10 corporations shared supplies, they shared employees, they probably were housed out of the same building. One day, one of the cabs ran over a pedestrian, Walkowski. And Walkowski was severely injured by this. When it came time to bring a lawsuit to try to get compensated for the injuries he had sustained, Walkowski wanted to do more than just sue the corporation that owned the taxi that ran him over. He wanted to make sure there was much money and assets available to satisfy any judgment that he might get. So Walkowski sued Carlton personally. And he said that Carlton had operated the 10 corporations in a manner that would justify the court in ignoring the corporate protection and hold Carlton personally liable for Walkowski's injuries. Now, why was that important to Walkowski? Why did Walkowski want the court to pierce the corporate veil? Well, here's the math. The corporation that owns the cab that hit Walkowski has a total of $20,000 in accident liability insurance and owns 2 taxi cabs as its assets. So, if Walkowski sued only this one corporation, the maximum amount he's going to be able to enforce his judgment against is $20,000 plus whatever the 2 taxi cabs are worth. But we're going to assume his injuries were far more serious than that. So he wanted to find more assets. Now, if Carlton had formed just one corporation that owned all 20 of his taxi cabs, that corporation would have had $200,000 in accident liability insurance and 20 taxicabs as assets. So much more likelihood, greater likelihood that Walkowski would be able to be compensated for all of his injuries if he could reach all of this insurance and all of these assets. So Walkowski claims that Carlton had abused the corporate privilege. Walkowski should be able to go against Carlton personally and collect from all of the corporations that Carlton owned. In deciding whether or not it should pierce the corporate veil, the court had to look at the two elements required before a court may do so. Number one, the court would have to determine whether or not Carlton dominated the corporations by ignoring their separateness. And if he had, the court would also have to decide if the domination was used by Carlton for an improper purpose. And in this case, although we don't have a lot of the facts, we can pretty much conclude that the answer to the first element, whether Carlton dominated the corporations, was yes. He didn't treat them separately as 10 separate businesses. Instead, as the facts tell us, he pretty much operated all 10 corporations as one company. They shared employees, they shared supplies, they shared resources. So because they were not run as 10 separate companies, the court will likely conclude that Carlton did dominate them. He did not respect them as separate businesses. But the second question the court has to answer is, even if Carlton dominated the corporations, did he use that domination for an improper purpose? Was he trying to defraud a creditor? Was he trying to avoid a law? When the court turned to this second question, here is where in this case they found that it was not appropriate to pierce the corporate veil. And the court reasoned that it is permissible for a person to try to limit his or her liability by using the corporate form, which is what Carlton had done here. The court further held that having insufficient assets to pay a damage judgment is not in and of itself a sufficient reason to pierce the corporate veil. There is nothing necessarily improper about not having enough assets to pay a judgment. Now, this was a case decided by a three-judge appellate panel, and two of the judges found that it would not be appropriate to pierce the corporate veil under these circumstances, but a third judge on the panel disagreed. And the third judge wrote a dissenting opinion, which is saying, I don't agree with the way the majority is ruling here, because the third judge believed that the corporations had been thinly capitalized. That means Carlton had not put enough money into each corporation to satisfy potential obligations the corporations might have. And clearly, one potential obligation a cab company might have is damages from car accidents, like we had in this case. The third judge felt that there were not sufficient assets put into the corporations to satisfy this very likely liability, and therefore this thin capitalization was a form of fraud on potential creditors of the corporations. I actually happen to agree with the judge who dissented. I think that in this case, Carlton had not put sufficient funds into his corporations, that it was a form of fraud on the creditors. But the majority court that issued the ruling disagrees with that. Right? Said nothing necessarily improper about not having enough assets to satisfy a judgment. So this case is a very good illustration of needing to fulfill both elements before the corporate veil may be pierced. Because in this case, the first element was fulfilled. Carlton did dominate these 10 corporations. He did not respect their separateness. But it's also required that that domination be used for an improper purpose. And in this case, the court felt that that second element had not been met. Now let's take these same facts and change them up just a little bit to illustrate how this case might have gone the other way. Let's assume that New York has a state law that requires all parties that employ more than 25 workers to provide paid family leave. And in order to avoid that law, Carlton sets up these 10 separate corporations and puts 3 workers on each corporation's payroll. However, just like in the scenario when we saw this case, he pretty much thereafter operated all of the corporations as one unit. So the employees all worked for all the other companies. They shared resources. They shared supplies. Now, one of the workers takes family leave, and the corporation that is that worker's employer refuses to pay for the leave time. The worker sues, asserting that the corporate veil should be pierced and that Carlton be treated as an employer of all 30 employees. So in this scenario, we have the same fulfillment of element number 1. There's domination of the 10 corporations by Carlton. But in this case, it's likely that a court would conclude that the second element is also fulfilled. That is, that Carlton used his domination for an improper purpose. The improper purpose in this case was to avoid the application of a law. If he would have hired all 30 employees with one corporation, he would be subject to the law. The fact that he set up 10 corporations, put 3 workers on each corporation's payroll, in order to avoid the application of that law, would be seen by the court as an improper purpose. So in that case, it's very likely that the court would pierce the corporate veil. The next problem that was assigned was problem 11. Problem 11 involves 3 shareholders of a Texas corporation that was involved in the moving business. So we have 3 shareholders, Castleberry, Branscombe, and Bybuth, and they each own 1/3 of the shares of Texan Transfer, Inc. After Texan Transfer, Inc. was incorporated and had been doing business for a while, Branscombe, one of the shareholders, then forms a new business that directly competed with Texan Transfer. Castleberry objected to this, and he sued to claim part ownership of Branscombe's new company. So, in order to settle the litigation, to resolve the dispute, Branscombe says, let me buy you out. Let me buy out your shares of Texan Transfer. And then I'll just be able to run both companies. So Castleberry agreed to that. And in settlement of his lawsuit, he sold all of his shares back to Texan Transfer. But Texan Transfer didn't have sufficient funds to pay him at that time. So Castleberry took a $42,000 promissory note from Texan Transfer. Then, once Branscombe had control of both Texan Transfer and his new company, he started to divert assets and business away from Texan Transfer. Right? He moved everything over to the new business. And that left Texan Transfer with no ability to pay the promissory note. It didn't have any assets. So Castleberry ended up receiving a total of $1,000 for his shares in Texan Transfer when he had been promised $42,000. Now, the promissory note was issued by Texan Transfer. But if Castleberry sues Texan Transfer, Texan Transfer doesn't have any assets to pay any judgment. So Castleberry sues Branscombe personally, claiming that the corporate veil should be pierced, and Branscombe should have to use his personal assets to pay the $41,000 that was left on the promissory note. So the court in problem 11 is going to have to go through the same analysis. It is going to have to decide the two elements necessary before a corporate veil may be pierced. Number one, was there domination of Texan Transfer by its shareholder Branscombe? And number two, did Branscombe use the domination for an improper purpose? Now, in this case, when Branscombe started moving assets freely from Texan Transfer over to his new company and diverting business that was Texan Transfer and moving it over to his other company, the court found that this was, in fact, domination of Texan Transfer by Branscombe, because he was not respecting the separateness of the two businesses. He was commingling assets. He was treating them really as one business that he controlled. The second issue for the court to decide in this case is whether Branscombe used the domination for an improper purpose. And in this case, the court said yes. It was clear that Branscombe was using his domination to avoid an existing obligation. Texan Transfer had an existing obligation to pay Castleberry $42,000. And Branscombe used his domination to deprive Texan Transfer of the assets necessary to pay that promissory note. So, avoiding an existing obligation, the promissory note, and also defrauding a creditor. Castleberry was a creditor of the corporation at this point. Those are improper purposes for which the court may pierce the corporate veil. And in this case, that is in fact what the court held. Branscombe was personally liable to pay the balance due on the $42,000 promissory note.